Hello students, welcome to EPG Pathshala. I am Dr. Neeti Goyal, Assistant Professor, Department of Commerce, Indira Gandhi National College, Ladwa, District Kurukshetra. Today, we are going to discuss regulatory framework across nations and human resource management. Learning outcome. After completing this module, the students will be able to know organizations, regulating multinational organizations, regulations of multinational by international organizations, social accountability 8000, NGOs, Indian labor laws. Everybody should know the law of the country in which he is residing, as ignorance of law is not considered in the court of law. Nobody can be excused for any mistake of law out of ignorance or illiteracy. Person who ignores law is liable for punishment. MNCs operate in multiple nations and they also have to adhere to the laws of each and every country where they operate. An organization can avoid costly penalties by complying to the local laws impacting business and keeping up to date with them. Every country has its own rules and regulations which need to be complied by the organization. As far as HRM is concerned, an organization must comply with all safety, health regulations and other relevant legislation applicable to the jurisdiction where the organization operates. This includes international guidelines, country, state and local laws that pertain to various areas of HR such as recruitment, benefits, labor relations and terminations, employees hired locally, management of employee. Keeping up to date with legislation ensures that the organization remains compliant and avoids costly penalties. Increasing globalization has seen large organizations doing business internationally or setting up operations overseas. Ensuring legal and regulatory compliance can be very challenging in a foreign environment where laws and business practices may be different. HR professionals must be well versed in the ever-changing arena of employment law to minimize the organization's liability in all aspects of HR operations. Human resources professionals must also take note of ordinances and implementing regulations and precedents set by federal and state courts and rulings of administrative agencies, other agencies enforcing employment-related laws such as the Equal Employment Opportunity Commission and the National Labor Relations Board. Regulation of multinational by international organizations, Business and Human Rights Resource Center, United Nations Global Compact, International Labour Organization, Organization for Economic Cooperation and Development, Clean Clothes Campaign, Regional Integration, the European Union. Business and Human Rights Resource Center. Business and Human Rights Resource Center is an independent organization having no concern with any government, religion, politics, nor it has any economic interest. The Business and Human Rights Resource Center tracks performance of around 7,000 companies operating in over 180 countries. It makes information publicly available. It aims to build corporate transparency and strengthen the corporate accountability. It also aims at advancing human rights in business and eradicating abuse. It makes companies address human rights concerns through communities and NGOs. It helps protect vulnerable people and communities against abuses. The Resource Center provides guidance materials and examples of good practice. It brings to light not only the criticism about the companies but also the good practices. It takes up various social like child labor, children rights, education, health, human rights, labor, poverty, gender equality, women empowerment, etc., environmental like biodiversity, environmental change, energy, water and sanitation, and governance issues like anti-corruption, peace and rule of law. United Nations Global Compact. The United Nations Global Compact is the world's largest corporate sustainability initiative by the United Nations to encourage business worldwide to adopt sustainable and socially responsible policies and to report on their implementation. The UN Global Compact has framed 10 principles for businesses relating to human rights, labor and government, labor, the environment and anti-corruption. Under the Global Compact, companies are brought together with UN agencies, labor groups and civil society. 10 principles framed by UN Global Compact for companies are: businesses should make sure that they are not involved in any human rights abuses. Businesses should support and respect the protection of internationally promulgated human rights. Businesses should endorse the freedom of association and should also uphold the effective recognition of the right to collective bargaining. Businesses should endorse the elimination of all forms of forced and compulsory labor. Businesses should endorse the effective abolition of child labor. Businesses should endorse the elimination of discrimination in employment and occupation. Businesses should hold a precautionary approach to environmental changes. Business should undertake initiatives to promote environmental responsibility. Should encourage the development and diffusion of environmentally friendly technologies, and also work against corruption in all its forms, including extortion and bribery. International Labour Organization (ILO). International Labour Organization is an agency of United Nations which deals with labour problems such as international labour standards, social protection and work opportunities for all. The International Labour Organization registers complaints against entities that violate international rules. However, it does not take action on governments. Multinational corporations have to adhere to the workplace related principles identified by the ILO. Through trade unions, labour movement lobby international organizations and have been successful in getting framed some work principles which should be respected by all nations. The principles offer guidelines to MNEs, governments and employers and workers organizations in such areas as employment, training, conditions of work and life, and industrial relations, for example, freedom of association, collective bargaining, abolition of forced labor, non-discrimination in employment, etc. In 1967, the ILO prescribed a code of conduct known as Tripartite Declaration of Principles concerning MNEs and social policy for multinationals. Organization for Economic Cooperation and Development (OECD). The OECD guidelines for multinational enterprises are the recommendations which have been addressed by governments to provide principles and standards for responsible business conduct. The principles and standards are voluntary in nature and are consistent with applicable laws. The guidelines are a supplement to national law but not a legal binding. The guidelines establish that the firms should respect human rights in every country in which they operate. Companies should also respect environmental and labor standards and have appropriate due diligence processes in place to ensure this happens. The guidelines aim to ensure that the operations of the business enterprises are in harmony with policies framed by the government. Mutual confidence between enterprises and the societies in which they operate get strengthened. The foreign investment climate gets improved and also aims to enhance the contribution to sustainable development made by multinational enterprises. Clean Clothes Campaign. Alliance of garment industries, labor unions and non-governmental organizations is Clean Clothes Campaign. The campaign focuses on improving the working conditions in the garment and sportswear industries. CCC has campaigns in 15 European countries and works with a partner network of more than 250 organizations around the world. The Clean Clothes Campaign insists that companies bear a responsibility and have the power to ensure that workers throughout their supply chains are treated fairly. The Clean Clothes Campaign has developed a code of labor practices for the apparel industry, including sportswear, based upon the conventions of United Nations International Labour Organization. The principles set forth in this code include, among others, a minimum employment age, safe working requirements, set working hours, and right to a living wage. The Clean Clothes Campaign pressures retailers and manufacturers to adapt the code of labor practices and ensure that the principles are upheld. Regional integration. The European Union. Development of the European Union has significant implication for industrial relations. In the European Union, social policy cover a number of issues, including in particular labor laws and working conditions, aspects of employment and vocational training, social security and pensions. The current treaty for the European Union is the Treaty of Lisbon, which came into force in December 2009, which guarantees the enforcement of a Charter of Fundamental Rights that covers civil, political, economic and social rights, which are legally binding not only on the EU and its institutions, but also on the member states as regards the implementation of European Union law. It also condemns discrimination on the grounds of gender, race and color, and mentions social rights of workers applied within companies. For example, workers' right to be informed, to negotiate, right to strike, etc. With expansion of European Union, there has been an increased sensitivity to the problem of social dumping, which refers to the practice of employing cheap labor than what is available at site of production or sale. Social Accountability 8000. There is now a universal standard for monitoring human resource management practices around the world, similar to the ISO 9000 quality standard, called the Social Accountability 8000, whose principles are drawn from the United Nations Human Rights Conventions. The role of HRM related to a global code of conduct include the following: drawing up and reviewing codes of conduct, conducting a cost-benefit analysis to oversee compliance by employees and relevant alliance partners, championing the need to train employees and alliance partners in elements of the code of conduct, checking that performance and reward systems take into consideration compliance to the codes of conduct. Non-government organizations, NGOs. NGOs have strengthened with time and make significant impact on the working of MNCs. These organizations have become internationalized now and have national managers in various countries and use different organizational structures for establishing coordination and accountability. They often impact the business policies relating to MNCs through protests and rallies. Laws affecting human resource management in Indian context. Labor laws are formulated for protection of labor or employees against exploitation by their employer. Labor laws also put certain restrictions upon labor or employees against their employer. Non-compliance of labor laws by the employee or labor make them liable for punishment or penalty by the court. Labor laws are the backbone for the human resource management. There is no validity for the human resource management without following the labor laws. Disobey of labor laws may lead to serious consequences like penalization or imprisonment or both. Every human resource manager must know the labor laws of that country where he is working, because most of the core HR functions are linked with the labor laws of the concerned country. The human resource functions of recruiting, selecting, training, performance appraising, compensating and attending to labor relations, safety, welfare and health concerns must relate to the labor laws of that country or state where the company operates. Critical issues like disputes resolving, women employees rules and regulations in mining, child labor and compensation in case of accidents, etc. The above said all issues are performed according to the labor laws strictly. Labor laws in India. The various labor laws in India are Indian Factories Act 1948, Child Labour Act 1986, Trade Unions Act 1926, Industrial Disputes Act 1947, Minimum Wages Act 1948, Payment of Wages Act 1936, Payment of Bonus Act 1965, Workmen's Compensation Act 1923, Payment of Gratuity Act 1972, Employee State Insurance Act 1948. Factories Act 1948. The Factories Act 1948 has been enacted to safeguard the interest of workers and to protect them from exploitation. It prescribes certain standards with regard to safety, welfare and working hours of workers apart from other provisions. The Act applies to every factory wherein 20 or more workers are ordinarily employed. The Child Labour Prohibition and Regulation Amendment Act 2016. A person who is under the age of 14 is called a child. An employing child in labour of any form has been declared as crime, which is liable for serious punishments according to the Child Labour Prohibition Regulation Act 1986. The law completely prohibits employment of children up to the age of 14, but allows them to help in family enterprises and farms after school hours and during holidays. Children working as artists in entertainment industry such as films, television serials or any such other entertainment or sports activities except the circus have been granted exemption if the work does not affect their school education. The Act also bans employment of children between 15 to 18 years in hazardous works in synchronization with the Right to Children to Free and Compulsory Education Act 2009. The Trade Union Act 1926. The trade unions are formed by workers voluntarily relating to specific trade, industry or a company to help and protect their interests and welfare by collective action. Trade unions caters to the workers' demand and also impart discipline and inculcate sense of responsibility in them. They are formed to provide wage security to workers and help secure better opportunities for promotion and training, secure jobs and provides for improved service conditions, improve working and living standard of workers, provide facilities for education, recreation and cultural activities, facilitate technological advancement of workers, promote individual and collective welfare, provides opportunity to participate in management for taking decisions regarding workers and to take disciplinary action against the worker who commits indisciplinary action. Some well-known central trade union organizations in India: All India Trade Union Congress AITUC, Bharatiya Mazdoor Sangh BMS, Center of Indian Trade Unions CITU, Hindu Mazdoor Kisan Panchayat HMKP, Hindu Mazdoor Sabha HMS, Indian Federation of Free Trade Unions, Indian National Trade Union Congress, National Front of Indian Trade Unions, National Labour Organization, Trade Unions Coordination Center, National Mazdoor Union. Industrial Disputes Act 1947. The purpose of Industrial Dispute Act of 1947 is to ensure securing industrial peace and harmony by establishing machinery and procedure for the investigation and settlement of industrial disputes by negotiations. This act deals with the issues such as layoff and retrenchment processes of the employees, procedures and rules for strikes and lockouts of the company. The act aims to protect the workman from being a victim of his employers. It ensures social justice to both employers and employees. The act promotes collective bargaining and aims to maintain a peaceful atmosphere in industries. Payment of Wages Act 1936. The Payment of Wages Acts regulate the payment of wages to certain classes of persons employed in industry. The Act guarantees payment of wages on time and without any deductions except those authorized. Provides for the responsibility of payment of wages, fixation of wage period, time and mode of payment of wages. Casts upon the employer a duty to seek the approval of the government for the deductions made by him and permission for such fines imposed by him. Provides for a machinery to hear and decide complaints regarding the deduction from wages or delay in payment of wages. Provides for penalty for wrongful claims. The Payment of Bonus Act 1965. The Payment of Bonus Act was formed with an objective for rewarding employees for their good work for the organization. It is a step forward to share the prosperity of the establishment reflected by the profits earned by the contributions made by capital, management and labor with the employees. The Act aims to improve statutory liability to pay bonus in case of profits or losses, to prescribe formula for calculating bonus, to prescribe minimum and maximum percentage bonus, to provide of set off or set on mechanism, to provide redressal mechanism. Payment of Gratuity Act 1972. The main purpose and concept of gratuity is to help the workmen after the retirement, whether the retirement is the result of the rules of the superannuation or physical disability or impairment of the vital part of the body. Gratuity is given to every employee without any consideration who has served the organization for more than 5 years. Employees State Insurance Act 1948. Scheme of health insurance for industrial workers is provided by Employee State Insurance Act. The Act provides for compulsory state insurance to cover certain benefits in the event of sickness, maternity and employment injury to workmen employed in or in connection with the work in factories other than seasonal factories. Employee State Insurance Corporation looks after the matter relating to the Act. Employees Provident Fund Scheme 1952. The Constitution of India under Directive Principles of State Policy provides that the state shall, within the limits of its economic capacity, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness and disablement, and undeserved want. The Employees Provident Fund Organization is a statutory body of Government of India under the Ministry of Labour and Employment. It administers a compulsory contributory provident fund scheme, pension scheme, and an insurance scheme. It is one of the largest provident fund institutions in the world in terms of members and volume of financial transactions that it has been carrying on. Applicability of the Employees Provident Fund Scheme. The Act applies to whole of India except Jammu and Kashmir. The Act is applicable to every establishment which has been specified under Schedule 1 of the Act or any specific activity notified by central government in the official gazette. Employing 20 or more persons. Cinema theatres employing 5 or more persons. The Workmen Compensation Act 1923. Employees Compensation Act 1923 entitles an employee to get compensation from employer for accidents arising out of and in course of employment. The Act was amended in the year 2009. The Workmen's Compensation Amendment Bill 2009 provides for the payment of compensation to workmen and their dependents in case of injury or death by industrial accidents. List of persons included in the definition of workmen has increased. The word workman has got substituted with the word employee so that the law is applicable to all types of employees and is gender neutral. The bill also omits the requirement that the place should have 20 employees. The compensation to employees increased in case of death from 80,000 to 1.20 lakh, in case of permanent disablement from rupees 90,000 to rupees 1.40 lakh. The bill allows the central government to revise the monthly wage from time to time. Employees should be reimbursed for any medical expense incurred for treatment of injuries during the course of employment. The funeral expense of the deceased workmen has been increased from rupees 2,500 to rupees 5,000. The bill allows state government to appoint any person as commissioner for workmen's compensation. The cases related to compensation should be disposed by commissioner within 3 months from the date of reference. Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Sexual harassment is defined to include unwelcome sexually determined behavior such as physical contact, request for sexual favors, sexually colored remarks, screening of pornography or any other conduct of sexual nature. The Act defines sexual harassment at the workplace and creates a mechanism for redressal of complaints. It also provides safeguard against false or malicious charges. The Act requires setting up of an internal complaints committee at each office or branch with 10 or more employees by every employer. Constitution of a local complaints committee at each district by the district officer and at the block level as well if required. The complaints committee has been vested with the powers of civil courts for gathering evidence. The complaints committee are required to provide for conciliation before initiating an inquiry if requested by the complainant. The Act provides for penalties or non-compliance with the provisions of the Act. Repeated violations may lead to higher penalties and cancellation of license or registration to conduct business. Maternity Benefit Act 1961. To safeguard the employment of women during the time of maternity, the Maternity Benefit Act 1961 has been framed. The Act also provides for maternity leave and entitles women to be paid full during the leave period to take care for the child. The amendments to the Act in 2016 seeks to increase maternity leave period to 26 weeks in all establishments including private sector. L'Oreal India has enhanced maternity leave to 26 weeks from 14 weeks earlier in an effort to retain high potential employees. It is also providing other facilities such as pre-commute assistance for expecting women employees starting from the 6 months of pregnancy and child care allowance for 2 years from the date of delivery, reduced work hours for 2 continuous weeks immediately after resuming work. L'Oreal India will also offer flexible working options to each parent as well as pre- and postnatal support and employee well-being sessions and dedicated human resource and management support. Conclusion: the human resource management cannot work in isolation. It has to adhere to the laws of the state in which it is operating, the local laws as well as the international laws pertaining to the various HR functions. The laws in each country administer and covers major regulations and statutes in the whole scope of employment, which includes workers and business. Every country has its own laws relating to labor depending upon the requirements of the business, economy and people. Labor laws include laws relating to industrial disputes, compensation, maternity, layoff and retrenchment. The laws of every country are different from each other. The HR manager has to frame policies for the overall organization in such a way that the overall organization policy remains same while respecting the local differences. Thank you.